Since 1978, when the first test tube baby was born in England, couples who were unable to conceive a child naturally have turned to in vitro fertilization, also known as IVF. This involved extracting an egg from a woman, putting it in a petri dish, and fertilizing it with sperm from a donor. The fertilized egg is then inserted into a woman's womb to develop into a baby. Several different scenarios may be involved in this process, such as the husband's sperm is used to fertilize his wife's egg, or the wife's egg is fertilized by the sperm of an unknown donor. The IVF process is successful approximately 50% of the time, and a child is born. Due to the 50% fail rate, several eggs are almost always fertilized at one time in separate petri dishes. The ones that are not inserted are frozen and stored in a clinic. They can be stored for years and can be inserted at any time. For those couples who actually stay together, they have the potential of having more children. In contrast, when couples divorce, when they have frozen embryos, a major question is, who owns the embryos? Now, before I get into the legal background of this, let me introduce the channel. This is the Legal Code, and on this channel we discuss a wide range of legal topics, whether that's celebrity shenanigans, things happening in the news, things that you should be aware of that are not spoken about in the news. I try to bring it to this platform so that you can be aware and know how to protect yourself and insulate yourself so that you're not caught blindsided. Now, if you like that sort of thing, please don't forget to like and subscribe, and please share with anyone else you think will find value. Also, I am a real-life attorney, so if you would like the opportunity to meet with me one-on-one to troubleshoot some area you may be struggling with, such as your estate plan, your business plan, you're exposed to some liability in your business and you want to go through and work through to protect yourself, we can discuss it in the consultation, and the link is in the description box. Now, without further ado, we're going to discuss how the law handles deciding who owns the embryo upon the divorce of the couple. There have been a number of cases where one party wants to keep the embryos and have them implanted, but the other party objects to becoming a parent and wants the embryos destroyed. Courts have struggled with coming up with a fair solution, balancing one person's desire to become a parent with the other person's objection to having a child. Most courts have concluded that the constitutional right to privacy that prevents government interference with the right to have children extends to the right of a person to not have a child. The balancing of rights weighs against forcing a person to have a child against his or her wishes. Courts have issued conflicting opinions about whether the embryos can be destroyed upon divorce or in accordance with the contract principles when the parties signed an agreement that in the event of divorce, the unused embryos will be destroyed by the clinic where they were stored. Some courts have enforced the contract, others have not, concluding that a couple should not be bound by a form they signed that was presented to them by the clinic years earlier. Usually, once the couple agrees, the two of them sign various forms required by the fertility clinic, including an agreement relating to, they have different titles, relating to embryo cryopreservation and embryo disposition. That agreement specifies that the embryo would be the joint property of the couple, so they will both need to consent to any future use, whether to implant it or to destroy it. It also covers what will happen if their relationship ends. So this document intends to lay out the different scenarios if the relationship is successful and they want to have more children, and if the relationship ends. The issue of who gets the embryos has come up over and over and over again. And there are more legal disputes about couples who have relied on IVF and who are still struggling. How to rule in these sorts of cases becomes sort of catastrophic for the courts. Although there's a contractual element, there is also a moral concern and a body autonomy concern underlying this issue. And most of the conflicts over the disposition of embryos is whether or not one person's right to procreate should prevail over another person's right to not procreate. Where courts tend to rule in favor of the party choosing not to procreate, following the theory that no one should be forced to become a parent. However, Arizona took us all by surprise by creating a law by privileging the right to procreate, totally defying the trend that supports the right to not procreate. Custody of disputed embryos must be given to the party who intends to help them develop them to birth. Arizona was the first in the nation to pass this kind of law. I am sure that you have all heard of the dispute between Sofia Vergara and her ex-husband Nicholas Loeb. Sofia Vergara won an ongoing legal battle that went on for years with her ex-fiancé Nick Loeb over their frozen pre-embryos. The former couple, who were together for 4 years before they split in 2014, had undergone IVF treatment together, and the pre-embryos are what resulted from that. Nick Loeb had sought full custody of the embryos, meaning in theory that he would be able to implant them in someone else, and the children could be born as a result of this. Now, the court found sufficient grounds existing for permanent injunction relief, meaning that Loeb, her ex-fiancé, would be unable to use the embryos or sue on behalf of them in any capacity without Vergara's consent. The court cited the form directive that they both signed at the fertility clinic, agreeing that both parties had to agree in order to do anything with the embryos. Loeb was of course not pleased with this ruling and sought to bring the case in other states, thinking that he would have a favorable outcome. But that has also been dismissed. So it looked like Vergara will not be forced to go through with this unwanted birth. So as you can see, the law concerning ownership of embryos is still in flux. So what are the lessons for thousands of couples that are relying on it or undergoing IVF each year? First, you will have to plan when you're undergoing IVF. You're also so focused on the possibility of having a baby that it can be hard to think about anything else. But that's the point at which a fertility clinic will be presenting you with an agreement about what to do with the leftover frozen embryos, as well as what to do in the event your relationship does not work out. Read the form carefully. You may be fortunate enough to have extra unused and your relationship works out successfully. You also have to think about, do you want to pay to keep them in storage for forever? Do you want to donate them to another couple for research? Or do you want them destroyed? Or you and your partner may split up. What should happen to the embryos then? Of course, you can always revisit your decision depending on the terms of the agreement later, but you and your partner will still need to agree on what to do. You need to communicate this to one another so that no one is surprised, and the fertility clinic also will need to be aware of this. Thinking about what will happen to your relationship in the future can add more stress. So filling out the agreement needs to be handled through careful conversation and discussion. And if you guys have lawyers, they should also be brought to the table as well, like a family lawyer, or seek out counsel that in the event this relationship doesn't work out, get the best and soundest legal advice that you can get, because not all relationships work out. So you need to do your best to plan if the relationship ends and what to do with the embryos. Now more and more couples are relying on IVF, and the first generation of couples who relied on it are now also probably becoming parents, because this goes back as 1978. So there's already 2 generations have relied on IVF. So now we're seeing a different dynamic be introduced where couples aren't working out, but they have the embryo and what to do with the embryo. So this is a burgeoning area of law, and it's not ironclad. And I wanted to do this video to present it to you because it's such a common occurrence. So many women are faced with this question, and then if it doesn't work out, what then? So I wanted to let you know the law as it relates to this area, that it's not ironed out in any jurisdiction except for maybe Arizona. And in that case, we know that the courts side with the person who actually wants to bring and help the embryo come to life. Whereas in other jurisdictions, courts are more conservative and they lean toward the right to not procreate and protecting that right. So let me know your thoughts. Let me know, do you think the courts are handling this appropriately in terms of leaning toward the person who does not want to procreate? Do you think there's an alternative that we have not considered? You can lay that out in the comment section, and don't forget to like and subscribe and share with anyone else you think will find value. And I will see you next time. Bye-bye.